the hospital trap that bankrupts seniors, and the 1930s law that still protects you cold open. Let's deliver on the promise in the title immediately, without delay. There's a trap embedded inside nearly every hospital in this country, and it rarely looks like one. It looks instead like compassion. A nurse offers a blanket. A physician says, almost offhandedly, "We'll keep you overnight, just to be cautious." You say thank you, your family says thank you. And 3 days later, you walk out of that building owing more money than many households earn in an entire year, because of a single administrative word that no one bothered to explain to you. Now, the second half of that promise. There is a law, a genuine one, enacted in the 1930s, during the most severe financial collapse this nation has ever endured, when millions of families were losing everything simultaneously. In some form, that law still exists today in nearly every state. Most people have never encountered it. Most people don't learn it exists until the collection notices have already begun arriving. But if you understand it beforehand, if you know it exists before a hospital bill ever lands on your kitchen table, it can mean the difference between losing your home and keeping it. By the end of this video, we will explain precisely what that law is and how it functions. Not yet, though, because you need to understand the trap in its entirety first, to appreciate why this old, largely forgotten piece of legislation matters so profoundly right now in your life, perhaps this very year. So stay with us. Somewhere in the next several minutes, a woman named Ruth is going to come dangerously close to losing nearly everything she owns. And then we will show you the exact legal safeguard that could have prevented it. Section 1. The word no one explains. Ruth was 74 years old. She had lived in the same modest house for 31 years. Within its walls, she had raised 2 children, said goodbye to a husband, and planted a garden each spring along the back fence line, precisely where the morning sunlight reached first. One Tuesday in October, Ruth felt suddenly dizzy in her kitchen. Her chest tightened. Her daughter Angela drove her straight to the emergency room, hands trembling on the steering wheel the entire way, praying under her breath without quite realizing she was doing it. At the hospital, physicians ran a battery of tests. They wanted to monitor Ruth's heart closely. A doctor eventually entered the room and delivered the sentence that countless families hear without giving it a second thought. "We're going to admit you for observation, just to keep an eye on things overnight." Admit you for observation. The phrase sounds official, even reassuring. There's a hospital identification bracelet. There is a hospital bed. There's a hospital gown, the kind that ties awkwardly in the back and never quite covers what it should. Ruth remained in that bed for 3 consecutive nights. Nurses checked on her every few hours. She ate meals delivered on a hospital tray. In every practical sense that mattered to a woman lying in that bed, she was a hospital patient in every meaningful way. Yet, in the specific language of medical billing, Ruth was never formally admitted at all. She occupied a different category entirely, one that most people have never heard of until it becomes financially catastrophic: outpatient observation status. Here's the trap, stated plainly. Hospitals across the United States apply 2 fundamentally different classifications to patients who spend the night. One classification is inpatient, the other is outpatient under observation. A patient in either category might occupy the identical room, on the identical floor, connected to identical monitoring equipment, cared for by the same rotating staff of nurses. From the patient's perspective, there is frequently no visible distinction whatsoever. From the insurance and billing perspective, however, the distinction is enormous. Being classified as outpatient rather than inpatient can fundamentally alter what insurance is obligated to cover. It can influence whether follow-up rehabilitation care receives coverage. It can change how medications administered during the hospital stay are billed. For a patient enrolled in Medicare, it can even determine whether a subsequent stay in a skilled nursing facility is covered at all. And here is the genuinely cruel part. The patient almost never participates in that decision. The classification is determined by hospital staff, according to billing criteria and clinical guidelines buried inside policy manuals that no one in that hospital room has ever been given the opportunity to read, let alone understand. Ruth did not select observation. No one consulted her. No one explained the implications. The term was used once, briefly, by an exhausted physician at 2 a.m, and the entire staff moved on to the next patient without a second thought. 3 days later, Ruth returned home, believing the difficult part was finally behind her. It was not. The difficult part had only just begun. Section 2, the envelope that changed everything. 3 weeks after Ruth arrived home, an envelope appeared in her mailbox. Angela still recalls, with unsettling clarity, the exact moment her mother opened it at the kitchen table, reading glasses perched on the bridge of her nose, sunlight streaming through the same window it always had. Ruth's expression shifted. Angela says she will never forget that particular sequence. Confusion first, then disbelief, then something closer to genuine fear. The bill totaled just over $18,000. Ruth had Medicare coverage. She had always been assured that Medicare would take care of her should something happen. She had contributed to that system across her entire working life. But because she had technically never been admitted, because she had spent 3 nights under observation rather than formal inpatient status, significant portions of her care were billed under entirely different rules than they would have been for a formally admitted patient. Certain medications administered during her stay were charged at outpatient rates rather than folded into a covered inpatient stay. And when her physician recommended a brief stay at a rehabilitation facility afterward to help rebuild her strength, Medicare declined to cover a single day of it because a specific federal rule requires at least 3 full days of inpatient admission before the particular rehabilitation benefit becomes available. Ruth's 3 nights in that hospital bed did not qualify, not a single one, because, on paper, she had never technically been admitted at all. The rehabilitation stay alone amounted to nearly $11,000, billed directly to Ruth, since Medicare's rule simply did not apply to her circumstances. Combined with her hospital charges, Ruth confronted a total bill approaching $30,000. For a single medical event, she had absolutely no way of anticipating, preventing, or even fully comprehending while it was unfolding around her. This is not an isolated story. It reflects something closer to a systemic pattern. Every year, patient advocacy organizations and Medicare watchdog groups receive thousands of complaints from families describing nearly identical experiences. A loved one stays in the hospital, functions as an inpatient in every practical respect, and is then billed as though never formally admitted at all. Some seniors describe spending an entire week under observation status before discovering, only when the bill finally arrived, that none of those days counted toward the coverage they had assumed they possessed. For families already stretched thin financially, an unexpected bill in the tens of thousands of dollars is not a minor inconvenience. It is a genuine crisis. It can mean draining a retirement account built over 4 decades. It can mean taking out a second mortgage on a home that was otherwise paid in full. It can mean an elderly citizen, someone who worked an entire lifetime expecting to spend their final years in relative peace, suddenly confronting collection calls, threatening correspondence, and the terrifying question Ruth herself finally asked her daughter one night, seated at that same kitchen table. "Hey, Angela, can they take the house?" Section 3. When the collectors began calling for a while, Ruth attempted to pay what little she could manage. She mailed small partial payments each month. She reduced her grocery spending. She stopped attending her weekly lunch with her sister because even that modest expense suddenly felt unaffordable. Angela offered to contribute, but Angela had her own mortgage, her own children, and her own mounting obligations. Then the phone calls began. Initially, they were polite, a representative from the hospital's billing office inquiring about payment arrangements. Then the calls started arriving from a collection agency rather than the hospital itself. A telltale sign, as Angela later learned, that the debt had been sold or reassigned, as unpaid medical debt so frequently is. The tone shifted noticeably. The letters grew more formal, more subtly threatening in the particular way collection correspondence always seems to manage. Phrases such as, "Before this matter proceeds to further action," began appearing in bold, deliberate print. Ruth did what many proud, fiercely independent people do under similar circumstances. She told no one how severe the situation had become. She refused to feel like a burden. She continued paying whatever she could and concealed the notices she could not answer. It was Angela who eventually discovered a stack of unopened envelopes in a kitchen drawer, months later, while searching for a spare set of house keys. That discovery marked the moment genuine fear took hold within the family. Unpaid medical debt, left unresolved for long enough, does not simply remain quiet indefinitely. Depending on the state and the nature of the creditor, unresolved debt can occasionally escalate into a lawsuit. A lawsuit can produce a judgment. And a judgment, under certain circumstances, can allow a creditor to attempt placing a lien against property the debtor owns, including, in the most severe cases documented in consumer complaints and legal forms, the debtor's own home. For an aging homeowner like Ruth, whose mortgage was already paid off and whose house represented her single most significant asset, that possibility carried a very literal kind of terror. Not the milder anxiety of "we may need to downsize," but the deeper, more visceral fear that the one tangible achievement of an entire working life might be seized entirely. Angela began searching everywhere for answers. She researched online late into the night, long after her own children had fallen asleep. She contacted a legal aid hotline and remained on hold for nearly 40 minutes. She spoke with a coworker, whose father had endured a remarkably similar ordeal. And during one of these conversations, almost as an aside, someone mentioned something Angela had never once encountered in her entire adult life. They referenced an old law, a statute that had nothing whatsoever to do with hospitals when it was originally drafted. A law born from an entirely different national crisis, generations earlier. designed to address a completely different category of family catastrophe, a law that, according to this particular acquaintance, might genuinely be the thing that saves your mother's house. Angela did not yet understand its mechanics. Neither did Ruth. But that single sentence set Angela on a path that would ultimately transform the entire trajectory of this story. We will walk that same path together. But first, it helps to recognize just how many families find themselves standing precisely where Ruth and Angela once stood. Because once the scale of this trap becomes clear, the significance of that old law becomes genuinely impossible to overlook. Section 4. A trap that ensnares far more families than most realize. Ruth's experience is not unusual. In many respects, it is disturbingly common. Consumer protection researchers and patient advocacy organizations have spent years documenting how frequently observation status, billing, surprises affect older adults enrolled in Medicare. Each year, hundreds of thousands of Medicare beneficiaries spend time in a hospital under observation status, rather than receiving formal inpatient admission. Many have no idea in the moment which category actually applies to them. Federal regulations eventually required hospitals to notify patients within a specific window if they were being held under observation rather than formally admitted. A modest measure intended to reduce exactly this kind of shock. Yet even with that notification requirement in place, patients and families continue describing the same experience again and again: a rushed conversation, unfamiliar terminology, and a genuine failure to grasp what the classification actually meant for the bill that would eventually follow. Older adults absorb the brunt of this trap for a fairly straightforward reason. They are statistically the most likely group to require hospital care in the first place. They are also the most likely to require follow-up care in a skilled nursing or rehabilitation facility afterward. And they are frequently living on fixed incomes, with a fully paid home representing the single largest asset they possess, leaving very little room in a monthly budget to absorb a surprise bill reaching into the thousands, let alone the tens of thousands. Adult children caring for aging parents describe a version of this story repeatedly across online forums, support groups, and consultations with elder law attorneys. A parent is hospitalized following a fall, a fainting episode, chest pain, or sudden confusion, something alarming enough to warrant a hospital stay. The family reasonably assumes that multiple overnight stays automatically constitute formal admission. No one thinks to raise the specific billing question, simply because no one is aware that such a question even exists. Weeks later, a bill arrives that contradicts nearly everything the family believed about their coverage. Elder law attorneys who specialize in precisely this issue often describe the emotional burden as being just as damaging as the financial one. Seniors who spent decades cultivating fierce independence suddenly feel powerless. Adult children already juggling careers, their own families, and the daily realities of caring for an aging parent must now become instant experts in medical billing terminology, appeals procedures, and collections law, often while their parent remains frightened, and frequently while that parent is still physically recovering from whatever originally required hospitalization. This is precisely what makes the trap so effective and so profoundly unfair. It never announces itself. No one ever says, "By the way, this classification decision could ultimately cost your family $30,000, and there's very little you can do to reverse it once it has been made." It unfolds quietly, buried within a passing sentence from an exhausted physician at an unusual hour, and the true consequences only surface weeks later, inside an envelope that arrives on an otherwise ordinary afternoon. But here lies the pivotal truth of this story, the one that finally shifts everything. While a family often cannot undo the initial billing classification once it has been made, and pursuing a formal appeal through Medicare and the hospital remains something every affected family should absolutely attempt, ideally with support from a patient advocate or elder law attorney. There exists an entirely separate layer of protection, independent of the bill itself. It has nothing to do with disputing the hospital's classification. It concerns what happens after that bill transforms into debt, and after that, debt begins threatening the one asset a family simply cannot afford to lose: their home. The protection is not a recent invention. It is not some clever loophole devised by an attorney last year. It has existed, in one form or another, since the depths of the Great Depression, when lawmakers across the country observed millions of families losing their homes to aggressive debt collectors and concluded that certain possessions should be considerably harder for creditors to seize than others. That is the law Angela was told about, and it is the law promised to you at the very beginning of this video. Section 5. The 1930s law that returned to save Ruth's house. Here it is, explained in full. During the Great Depression, home foreclosures and forced property seizures occurred at a scale this country had never previously experienced. Families who had constructed their entire lives around a single piece of property watched creditors seize that property over debts that, under ordinary economic circumstances, might never have spiraled so severely. Lawmakers across state after state responded by strengthening, or in some cases creating entirely, what are formally known as homestead exemption laws. Legal protections specifically designed to shield a portion, or in certain states the entirety, of a family's primary home equity from seizure by unsecured creditors. Unsecured debt is the precise legal term for exactly the type of debt consuming Ruth's finances. Hospital bills, medical expenses, credit card balances, debt not tied to collateral in the way an auto loan or a mortgage typically is. Homestead exemption laws emerged in substantial part as a direct response to that Depression-era wave of family devastation, intended to ensure that a roof over one's head could not so easily be pulled away by unsecured creditors, even in the presence of a valid court judgment. Here is precisely how it functions in practice, and this is where the story becomes genuinely hopeful for families like Ruth's. In most states today, a homestead exemption protects a specific amount of equity in a person's primary residence from unsecured creditors, both during bankruptcy proceedings and, in numerous states, during standard debt collection efforts occurring entirely outside of bankruptcy. Some states protect a fixed dollar amount of home equity. Other states, including a handful such as Texas and Florida, protect the entire value of the home with virtually no dollar limit whatsoever, provided certain residency requirements are satisfied. Other states occupy a middle ground, protecting a moderate but meaningful amount of equity, frequently enough to shield an older homeowner like Ruth, whose home was fully paid off and valued below the protected threshold in her particular state, from ever losing that home to a medical debt collector, regardless of how aggressive the collection efforts eventually became. This is the detail almost no one explains to families precisely when they need it most. A collection agency pursuing a medical bill will rarely, if ever, volunteer the information that a debtor's home might already be legally shielded from their collection tactics. Their function is to collect payment, not to educate debtors about the legal protections available to them. Many families, understandably terrified by aggressive letters and repeated phone calls, assume the worst-case outcome, that losing the house is not merely possible, but likely, perhaps even inevitable. In reality, across the majority of states, a primary residence with a modest equity proves far more difficult for an unsecured medical creditor to actually seize than most families realize, precisely because these Depression-era homestead protections continue sitting quietly within state law today. For Ruth, this knowledge transformed everything. Once Angela connected with a legal aid attorney specializing in elder financial matters, the family discovered that Ruth's home, modestly valued and entirely paid off after 31 years, fell comfortably within her state's homestead exemption protection. Even in a worst-case scenario in which the medical debt collector pursued and obtained a formal judgment against Ruth, that homestead protection meant the collector could not force the sale of Ruth's house to satisfy an unsecured medical debt. The house itself, the singular asset representing an entire lifetime of labor, memory, and stability, had never genuinely been at risk, despite every collection letter Ruth received suggesting otherwise. That revelation did not make the underlying debt vanish. Ruth and her attorney continued working through negotiations directly with the hospital's billing department, applying for hospital financial assistance programs that many nonprofit hospitals are legally required to offer yet rarely advertise, and formally appealing the original observation status classification through Medicare's official appeals process. Portions of the bill were subsequently reduced. Other portions were forgiven entirely under a hospital charity care policy for which Ruth qualified based on her income, though she had never previously known to inquire about it. What ultimately remained was restructured into a manageable payment plan Ruth could genuinely sustain on her fixed income without a constant undercurrent of dread shadowing every month. Yet beneath all of that practical, exhausting work, one fact provided Ruth with something she had not experienced since that first envelope arrived: authentic safety. Legal, documented, unshakable safety. Her home, the house with the garden planted along the fence line, the house where she raised her children and eventually said goodbye to her husband, remained protected by legislation written generations before Ruth herself was even born, by lawmakers responding to an entirely different crisis, who could never have anticipated a woman named Ruth, or a billing classification called observation status, and who's nonetheless constructed something durable enough to reach forward across nearly a century and protect her regardless. That is the promise this video made at the very beginning. The hospital trap is genuinely real. It ensnares careful, honest, hardworking people who did absolutely nothing wrong beyond trusting the very system meant to care for them. But the protection is equally real. It has rested quietly within state law for generations, waiting to serve exactly the families who need it most desperately, provided they discover it before fear takes complete hold. Closing. What to do if this is happening to you or someone you love. If you or someone you love is confronting a hospital bill stemming from an observation status stay, or any overwhelming medical debt more broadly, There are concrete, sequential steps worth pursuing. First, request a formal, fully itemized bill and determine in writing whether the stay was classified as inpatient or outpatient observation. This single detail fundamentally alters what can be appealed and how. Second, if the patient is enrolled in Medicare, investigate the Medicare appeals process specifically designed for observation status disputes, and consider contacting your local state health insurance assistance program, commonly known as SHIP, which offers free, impartial counseling to Medicare beneficiaries navigating exactly this kind of dispute. Third, contact the hospital's billing or financial assistance office directly and inquire specifically about charity care or financial hardship programs. Many hospitals, particularly nonprofit institutions, are legally obligated to offer such programs, yet rarely publicize them, and countless families qualify without ever being informed. Fourth, and this is the detail so many families never discover until it is nearly too late, research your own state's homestead exemption laws, or consult a local elder law or consumer protection attorney regarding how those protections specifically apply to your home and circumstances. Many legal aid organizations offer free or low-cost consultations for exactly this purpose, and the genuine peace of mind that comes from knowing your home is protected, even amid an ongoing debt dispute, proves worth far more than most people realize until they finally possess it. Ruth still tends her garden along that fence line every spring. She still lives in that house. Resolving the bill required months of persistent effort, extensive paperwork, and difficult conversations. But the house itself was never truly at risk once the family finally understood the protection that had quietly existed all along. That is the trap. And that is the law that still protects you. Share this with someone who needs to hear it before that envelope ever reaches their own kitchen table.